as summer just flies by, but we appreciate being able to present to a large group all across the country. That being said, we're mindful, and I want to remind you all to be mindful that these legal developments are moving swiftly. And so the information that we're sharing with you today is accurate as of 11:30 p.m. this afternoon. At the end of the webinar, we'll be providing links to resources, including some trackers that should help you keep abreast of the relevant changes that are likely to be coming in the next few weeks. So to start, again, like I just mentioned, we're not offering you legal advice as this area of the law is quickly changing. The webinar is going to focus on the states within Holland Hart's footprint, including Alaska, Colorado, Idaho, Nevada, New Mexico, Montana, Utah, and Wyoming. So though we do have attorneys licensed in all 50 states, so if you have specific questions related to states where you may have operations or employees, please don't hesitate to reach out to any one of us so that we can provide you with the resources or get you in touch with one of our wonderful colleagues who will be able to provide guidance for some of the states that we're not going to touch on today. Gone through all this earlier. So as a result of the Supreme Court's decision in Dobbs, there are two types of laws that are implicated and relevant to our discussion today. The first are the zombie laws, quote unquote, which were enacted pre-Roe and were never rescinded, but also never enforced. These laws prohibited abortion and remained on the books in many states, despite the court's decision in Roe. In addition, there are trigger laws. These are laws that were adopted by state legislators after Roe that contain an exclusive provision that they would go into effect if and when the Supreme Court overturned Roe and Casey. So collectively, they're both being used in the Mountain West to impose criminal liability for abortion, and in some states, some civil liability potentially also for aiding and abetting an abortion. And the dominant theory right now is that both zombie laws and trigger laws have been activated in light of the Supreme Court's decision in Dobbs. Briefly touch on the current status of abortion laws in each of the Mountain West states. Christy is going to come in and dig a little deeper on what those laws mean specifically for healthcare providers. I'll jump back in and discuss the relevant implications for employers. And then finally, Beth is going to close the webinar with and discuss federal preemption and some employer benefit guidelines. Afternoon, lawmakers in Alaska, Colorado, Nevada, and New Mexico have recognized abortion protections either by statute or by the High Court. So in these four states, remain protected. While we're narrowing our focus on the Holland and Hart footprint, we did just want to mention that some states like Colorado, including Colorado, have passed legislation that explicitly protects the right to have an abortion. Though it's unclear if any of these more liberal-leaning states in the Mountain West will pass legislation similar to that in California and Connecticut, for example, which have recently created explicit protections for persons traveling to those states to receive an abortion, and even creating, in some cases, civil causes of action for recouping attorney's fees in defending against Texas-style SB 8 lawsuits. Ultimately, like any good lawyer will answer, it's all going to depend. Litigation in each state will likely be the only resolution for these complex and cross-sector implications, and Holland Hart will do its best to let our clients know if and when things change. Now, in Montana, abortion will remain legal. It's likely to remain legal. However, just keep in mind there is some commentary that the legislator may be intending to pass new restrictions, which would ban abortions at 20 weeks. But again, as of right now, there is no trigger law or zombie law that has gone into effect in Montana. and Wyoming, each state had a trigger law that was in place and set to go into effect upon the overturning of Roe. In Utah, the trigger law was automatic, and as I'm sure many of you know, the Utah State Trial Court recently issued a permanent injunction banning the abortion statute from being enforced. So until that preliminary injunction is appealed, and then until a determination by the Supreme Court is reached in Utah, that trigger law is being enjoined by the preliminary injunction. Similarly, in Wyoming, the court has recently issued a temporary order, which is for the time being, while the courts issue a determination on some lawsuits that were filed. Abortion bans violate the state's constitution. Branches of each of these states determines the state constitutionality. We wanted to provide you with an overview and analysis of what enforcement of these trigger laws would mean if and when they do go into an effect. So with that, I'm gonna pass it over to Christy. And again, keep in mind, we are going to be giving you all, it will be a lot of information, but we'll try to give you, point you in the right direction if you need more information. Christy?
Thanks, Camila. And I'm just going to mention, Camila, directly to you, there is some audio problem, but hopefully the slides are helping people, keep track of information. But Camila, while I'm talking, you may want to talk to, Luke and Charles and try and make sure that your audio is a little better when you come back in. So I'm going to be giving an overview of these. There are 3 states within the Intermountain West that have these trigger laws that are expected to go into effect at some point in time. And I'm going to give you an overview of those. So I'm not going to be talking about the current status of abortion laws in these 3 states. We're going to be talking about if these trigger laws go into effect, what will be the status of the law at that point in time. So I just want to make that clear. I'm assuming that everybody's familiar with their own state laws related to, abortion that have, been in effect for some time. So with that being said, I'm going to start off talking about Idaho, and I will say that Idaho is pretty complicated. And I have given you the link later on in our slide deck to some client alerts from Kim Stenger, one of our healthcare partners based in Boise, talking about the complications and some of the confusion around Idaho laws related to abortion, because there are multiple that are layered on top. And right now there's been, a little bit of confusion given what's happening with the overturn of Roe v. Wade. But there are 2 trigger laws in Idaho. One is civil and one is criminal. So there are 2 separate trigger laws in Idaho that, were supposed to go into effect if Roe v. Wade was overturned. The first one, the civil statute, it's currently stayed by the Idaho Supreme Court, and there's a hearing on August 3rd. With the criminal, it's supposed to go into effect on August 25th, unless it is stayed by the Idaho Supreme Court. So in relationship to that, I'm going to just kind of give you a brief overview and kind of summarize these laws. So the things that I think that especially healthcare providers and facilities need to really closely look at and think about where you live is, first of all, how is abortion defined? And you've got to know that definition to really understand how to navigate these laws. So in Idaho, the definition of abortion, it's really the use of any means to intentionally terminate a clinically diagnosable pregnancy of a woman with knowledge that the termination by those means will, with reasonable likelihood, cause the death of this preborn child. So that's going to be important, right? Clinically diagnosable. Certainly, pregnancy tests, don't work for several days, right? After somebody, after, an egg is implanted on the uterine wall. That's when you start to get the hormone, right? HCG being released. So I think that that's an important distinction under Idaho law about the definition of abortion. So if it can't be clinically diagnosed, if there's no way that anyone could be aware of that, that should offer, some, guidance for healthcare providers as they're trying to navigate this. Another aspect that I think is really important under Idaho law, and it's not listed in the summary because it's tough to get everything into one slide like this, but I wanted to mention that Idaho and some states around the country, they've explicitly in Idaho said that abortion, for the purpose of, the definition of abortion under Idaho law, does not mean the use of IUDs or birth control pills that inhibit or prevent ovulations, fertilization, or the implantation of a fertilized ovum within the uterus. So it's nice that Idaho at least put in that explicit, exception to that definition so that healthcare providers clearly know that, the prescribing of certain reproductive health devices, birth control pills, again, you don't need to be concerned about that. Anything that's going to, again, prevent the fertilization or implantation of that egg is accepted out from the definition of abortion. In terms of the next thing I think that all providers need to be aware of is in your state, how is pregnancy or conception defined? Like, when does this start? In Idaho, that definition specifically says that it's with the fertilization of the egg. Typically in the healthcare field, people consider a pregnancy, doesn't start until that egg implants on the uterine wall. But you'll see that many of the states around the country have specifically said it's when the egg is fertilized. And again, that's how it's defined under Idaho law. But if you read that in conjunction with, again, the definition of abortion, if a pregnancy cannot be clinically diagnosed, it's not an abortion. There are exceptions, of course, under each of these laws. For the civil law, the civil trigger law in Idaho, there's an exception for the medical emergency to save the life or avert impairment to the mother. There's an exception for rape or incest if reported to law enforcement and a copy of that report is provided to the physician prior to the abortion. On the criminal side of things, there are exceptions to prevent the death of the mother, but it's got to be performed in a manner to give the child the best chance at life, if possible. Also, there's an exception for rape or incest. Again, if it's reported to law enforcement and a copy of that law enforcement report is provided to the physician prior to conducting the abortion. I do want to mention as well that in Idaho, these civil and criminal, penalties for violating these trigger laws that may go into effect, they apply to anyone, not just physicians. So wanted to make sure that you're aware of that. The other thing that Kim Stinger asked me to mention is that in Idaho, there is another law that legally has sprung into effect given the overturn of Roe v. Wade. And so right now, Idaho has a law that has sprung into effect related to that after 20 weeks, an abortion cannot be performed, of course, except for these accepted out items. So while we're waiting to see if these other two trigger laws will go into effect, right now Idaho needs to follow its applicable law that sprung into effect related to that 20 weeks. And there are more specifics about that. And again, there's a link to Kim's client alert, which will give you more detail on that point. So let's turn to Utah. Utah, the penalties, it's felonies. There are some misdemeanors, but it's up to a second-degree felony. And then there can be licensure risk for anyone that is licensed, like a physician, a PA, nurse practitioner, if they violate these abortion statutes. And it also, our trigger law allows for also an abortion clinic to face licensure action and individuals, of course, involved in an abortion clinic that are found in violation of the abortion law to, again, suffer these criminal penalties. In terms of the status right now, there is a preliminary injunction still in place with Utah. So right now, our trigger law is not in effect. So you'll need to be, closely monitoring the current court case to see if that is overturned. But right now, there is an injunction precluding enforcement of this trigger law. Again, let's look at the definition under Utah law of abortion. And that is the intentional termination or attempted termination of human pregnancy after implantation of a fertilized egg through any kind of medical procedure or substance that's used under the direction of a physician or by a physician. There are a couple of other definitions that they're trying to be very comprehensive in this trigger law, but in some, that's what it comes down to. And our law specifically excludes the removal of a dead unborn child, like say a stillborn child, miscarriage, or an ectopic pregnancy. So with that, now looking at how is pregnancy defined? Most of these laws actually will talk about conception and pregnancy and give definitions. Utah's trigger law does not, but obviously based upon the definition of abortion, including this statement about after implantation of an egg, I think we can safely infer that they believe that conception or pregnancy is happening after implantation, not upon fertilization. And I want to just mention here, why is that important, right? This is important because we've been getting questions from providers around the Intermountain states and across the nation, frankly, when they have laws in their state that specifically talk about conception happening upon fertilization, and their abortion statute talks about, the intentional ending of a pregnancy. This has created concern for many providers about, okay, so if I suggest, if I have, if there's a woman that's had unprotected sex and I suggest she go and get Plan B or provide a prescription, is that going to be considered abortion, right? There's a lot of fear around that. And the same, applies, let's say, to an IUD, right? Because an IUD, while generally we're going to be preventing the fertilization of an egg, there is the possibility, right, that it can prevent the implantation of that egg on the uterine wall. So that's why I just want to talk about, again, these definitions of pregnancy and the concerns. But, specifically here in Utah, again, you've got the definition really running after it's implanted in the uterus. In terms of exceptions under Utah law, the exceptions are to avert the death or serious risk or substantial and irreversible impairment of a major bodily function of the mother. The fetus has a defect that is uniformly diagnosable and lethal, or there is a severe brain abnormality. You should note that under Utah law, there are very specific definitions of what that means. And things like Down syndrome, spinal bifida, those are not, those do not qualify. So you'll need to, look very closely at those definitions to determine, what actually does count under the law for being able to have a legal abortion in that situation. But of course, the physicians that are involved are going to be looking very closely at these and should know. There also is an exception under Utah law for rape or incest. However, it must be reported to law enforcement and must be verified by the physician prior to abortion. And in the case of incest, that would qualify under Utah law, of course, as child abuse. And we have a mandatory reporting law when a physician or anyone actually in the state of Utah is aware or has a reasonable belief that a child is being abused or is in a situation that could lead to abuse or neglect. So in that case, the law also says that the physician would need to report to, they would need to follow a mandatory reporting law, which says that they've got to report to DCFS or local law enforcement. They've got to report that abuse. So they need to do that in addition to, reporting it to law enforcement. So you've got to follow that mandatory reporting law if it's a case of incest and thus there's abuse. So let's turn now to Wyoming's law. Wyoming makes it a felony for anyone that's performing abortion that's contravening this trigger law. However, it is not in effect yet. There is a preliminary injunction hearing that's set to take place next week. Under Wyoming law, abortion is defined as any act, procedure, device, prescription that is given to a pregnant woman with the knowledge of the pregnancy, including the pregnant woman herself, with the intent of producing, basically a termination of this pregnancy. So again, these are really important definitions. These words are so critical to really look at. But the Wyoming legislation, this trigger law, makes it very clear that abortion only exists if there is knowledge, of a pregnancy. And you've got to have the intent to terminate that pregnancy. Now, in Wyoming, they also discuss that the statute says that basically conception or pregnancy, that begins upon fertilization, not implantation. So again, there's kind of this fear about, well, what about, IUDs? What about Plan B, emergency contraception that could keep a fertilized egg from implanting on the uterine wall? When I've looked at this issue, and for anybody that's in a state that kind of mimics this kind of language in their abortion law, again, looking at when somebody can have knowledge of a pregnancy, that's normally going to be, 7-8 days after that egg implants on the uterine wall, so that there's enough HCG to show up on a pregnancy test. If there's no way to diagnose that there's a pregnancy, then obviously no one has the knowledge of a pregnancy, and there's not an intent, right? So giving, Plan B or an IUD in that situation where there literally can be no knowledge of the pregnancy, because you certainly don't know if there's been an egg that's fertilized. All you know is once that HCG, starts showing up, right, in the blood. So those are just some things to kind of keep in mind. In Wyoming, they do have the exception to avoid the death or substantial and irreversible impairment to the mother, but that does not include psychological or emotional conditions. And then they do have an exception for incest and sexual assault. And in Wyoming, it does not include the requirement that be reported to law enforcement. So that should give you a nice overview of those laws. The questions that are really coming up about this, we've already talked about, Plan B, IUDs, what does this mean? And hopefully we've given you a framework to think about those wherever you're living, if you have these trigger laws that may go into effect. But some of the interesting questions that have come up is, well, what about IVF, right? In vitro fertilization. So people that are having a difficult time, obviously getting pregnant, and they're going to these IVF clinics, and normally, you've got these embryos, right? And these are fertilized eggs, and they'll have a lot of these, and normally those are frozen until such time as they need to be utilized. So there's a lot of fear around this. Well, our IVF clinics are going to be prosecuted as in some of these states that say that conception or pregnancy occurs upon fertilization. Are they going to be guilty, right, or accused of abortion when the clinic disposes of these fertilized eggs? Are the parents, right, that have these fertilized eggs, if they ask for those to be disposed of, are they going to be accused of abortion? Now, some states, I don't think thus far that the IVF is addressed in any of the state laws, but you do have certain state officials that are coming out and saying, we are not going to be prosecuting that. But it's this question mark and this concern, right, based upon the language of these statutes. And so I think what we're going to see is a lot of these states starting to address these nuances in future legislation. So you'll want to keep an eye out for that. The other, things that are just interesting, right, is when you start defining, personhood, at the time, even a fertilized egg, there's going to be a lot of, it's really kind of the wild, wild west right now in terms of the law, because there's so many unanswered questions. And you've got a lot of, national, highly regarded law professors that are saying this definition of personhood being literally upon an egg being fertilized or at implantation, this is going to lead to a lot of legal implications that people probably haven't even thought about, right? Ranging from everything from minor traffic violations to criminal prosecutions, child abuse. If somebody has a glass of wine and they, may be pregnant, is that going to, under the state's child abuse laws, does that amount to child abuse? So there are all sorts of implications that are going to have to be really ferreted out. And I think you're going to see, again, additional legislation coming out trying to address some of these issues, and you're going to see a lot of legal battles. So moving on, just wanted to kind of briefly hit on some other issues. One of the other things in healthcare that everybody's grappling with is we've got federal laws, and now we've got these, in some states, you've got these abortion laws set to go in effect, or in some states are now in effect. And what preempts with some of these federal versus state laws? And again, legal scholars, there's going to be a lot of litigation about these matters, and we don't have bright line answers on some of this, but there is some guidance out there, which I wanted to discuss with you. So for specifically, let's talk about HIPAA. People are very concerned, right, that their PHI, their protected health information related to their reproductive health, will that be obtained by, let's say, law enforcement or, AGs, prosecutors? Will that be obtained in an effort, right, to prosecute different people or get certain evidence? As most people probably on this call understand, HIPAA generally prohibits healthcare providers from disclosing PHI pursuant to subpoenas and other government demands unless certain conditions are satisfied. However, there are exceptions where, for, let's say, a court order, there's a warrant signed by a judge, a subpoena signed by a judge or magistrate, or a grand jury subpoena. Those are situations where you're literally being ordered with the force of law to do something. And if you fail to comply, that can result in fines, penalties, being subject to discipline by the court. So in those situations, healthcare providers don't have much choice but to comply with those items. However, Health and Human Services did release guidance trying to emphasize to healthcare providers that under HIPAA, these are exceptions where you may provide the PHI, but you're not required under HIPAA. But that guidance is a little bit misleading or maybe optimistic, because while HIPAA doesn't say, oh, if you get a court order, you have to give the PHI. Of course, it's just saying that you can in that situation. Again, under the force of state law that's behind these court orders and warrants signed by a judge, you're under the force of law to provide that. So I think we will see, though, if we see prosecutors, law enforcement that are issuing those to healthcare providers, for the purposes of trying to prosecute in this situation, you might see some legal battles, right? Where I suspect we will see some providers being willing to litigate over that issue and really kind of digging in their heels. But I just wanted to mention that, this is obviously an issue, and healthcare providers get plenty of, court orders or warrants signed by judges and these subpoenas signed by judges where, we look at it carefully as healthcare attorneys, and then we tell our clients, okay, yeah, this is valid and it has the force of law, so you need to follow this, with exactness. And those are going to be difficult situations. Moving on, just a few other things to consider. In regard to EMTALA, right? So we're talking about the federal law related to emergency care. And it's specifically, the requirements, right? The hospitals, anybody providing this emergency care, that they have to follow. And if they fail to do it, the hospital can face penalties, including being excluded from participation in Medicare and Medicaid. But providers, if they fail to follow EMTALA and provide the emergency care as required under EMTALA, they can also face those same penalties. So there's been this concern in states where, let's say, these trigger laws have already gone into effect, and you've got somebody that presents at the emergency department with an ectopic pregnancy. Well, that is at least eventually going to put her life, right, at danger. It's not going to be a pregnancy that can continue. But there's been a lot of fear by some emergency department physicians, like at what point does that person have to get to where her life is in danger so that I can feel safe to provide, that abortion, remove that fertilized egg in that situation. So the federal government has issued guidance to healthcare providers about that, reinforcing that here federal law preempts when it comes to EMTALA and emergency care that's needed. And they've issued additional guidance saying that, the emergency department physicians do not have to wait, right, until, the mother's vital signs are crashing, to administer that. So read that guidance. I think that link is going to be very helpful. Again, I think that there's still some fears. Texas now is suing the federal HHS over this guidance, trying to say that this is not appropriate. So again, there's going to be some serious litigation over these things, but this guidance, at least, I think, is helpful. And the risk of not complying with EMTALA is pretty severe. Pharmacists have had concerns about, am I going to be held liable if I provide a prescription that could induce an abortion, but it could be for arthritis, right? Or it could be a woman that's actually, the pregnancy has been lost, right? But they need her to, expel the fetus. They give these medications that can induce an abortion, right? They give them in those situations too. And there's been concern by pharmacists, if I give this, am I going to be accused under my state laws of helping with an abortion? So the HHS has also issued guidance to pharmacists about this. So you'll want to read that guidance pretty carefully. And basically what they're saying is that under the ACA, that you could be found liable under federal law for discriminating against a woman, basically because of her sex, because pregnancy is included as discrimination based upon gender and sex. So they've issued guidance, but of course there's also, these religious exceptions under federal law too, that a pharmacist doesn't have to do something if, morally they don't feel good about it. So there's kind of some conflicting things there, but I'd encourage you to read that guidance for pharmacists if there are any pharmacists that are listening today. And then there's also been, Health and Human Services also issued guidance to patients about their rights related to reproductive health care. There's also been guidance issued related to participants in research studies. There's also been guidance related to how to protect your health information, let's say in apps that you're using, your period trackers. So right now, I think, imbibe as much of this guidance as you can to get a feel, but in terms of how things are going to play out fully in terms of what is applicable here, state or federal law, when push comes to shove on some of these issues, there's just going to be litigation, and it's going to be a few years before we know what's going to preempt in some of these situations. But of course, for our hospital clients, we advise that the penalties and the repercussions of not following, for example, EMTALA, that's severe, and you basically would be out of business. So you're going to have to weigh some of those risks and comply the best you can. I've given some links to some other helpful resources, especially on Idaho abortion, these trigger laws. So please read those. When it comes to HIPAA and disclosures to law enforcement and guidance related to that, including also subpoenas, court orders, administrative demands, I've included links to some of our client alerts on those topics, and I encourage you to carefully read those. And then if you have any other questions related to healthcare, please feel free to reach out to me. And with that, I'm going to turn the time back over to Camila.
Better? Is this audio better? Christy?
Camila, it's still cutting out at the very beginning. When you start to speak, it will cut out. So I don't know if you want to go off of your headphones, but.
We'll try this. I might switch back. As you mentioned, where a healthcare provider may receive a subpoena for documents of patient data, if an employee becomes the subject of a criminal investigation or prosecution after terminating a pregnancy in a state where abortion is illegal, law enforcement officials would be able to serve a subpoena or search warrant on an employer. So in the same way that it's relevant for a provider as an employer, there is the potential that you all would need to provide discovery in a criminal or civil context. In the civil context, under the Idaho-Texas copycat law, if an Idaho employer were named as a defendant in the state, similarly, all relevant non-privileged employee browsing or personal information could be discoverable in that state. And to date, neither Utah, Wyoming, nor Idaho have specific employee privacy laws that would protect this information from being discoverable. So it's important to reiterate your employees that their use of company devices and technology is rarely private and would be discoverable in both a criminal or civil context. Again, just some other things that we've noticed may come up from the employer-employee perspective. Title VII of the Civil Rights Act, coupled with the Pregnancy Discrimination Act, which I believe Beth is going to talk a little bit about as well, would prohibit an employer from firing an employee for having or considering to have an abortion. Though receiving an abortion is not an explicitly protected activity under Title VII, the EEOC has indicated that it would be a violation of Title VII to subject an employee to an adverse employment action for obtaining an abortion. Where Title VII does not require an employer to provide pregnancy-related leave if it does not provide leave for other temporary illnesses or family obligations under the Americans with Disabilities Act, coupled with the Pregnancy Discrimination Act, PDA, an employer may be obligated to provide a reasonable accommodation of unpaid leave for a woman experiencing pregnancy complications, et cetera, in a state where abortion is prohibited, and then they had to travel to receive the abortion. So though pregnancy alone is not considered a disability under the ADA, if a pregnant person is experiencing complications, they may be considered disabled, and therefore an employer would need to engage in the interactive process regarding reasonable accommodation, including potentially unpaid leave. Similarly, under the FMLA, an employee may be entitled to take time off for abortion-related care. This would likely include the days required for travel if a covered employee had to travel out of state for the medical procedure. And again, this isn't an additional obligation. It would just be an employer would be required to comply, or the employee would be required to comply with all the policies and procedures regarding the use of FMLA. In addition to these federal statutes, like Title VII and FMLA, I'm going to hand it over to Beth, who's going to discuss some additional federal preemption and post-doc implications regarding employment health plans. Beth?
Hi, thanks,
and then I think we'll push it over to Beth. Yeah.
Hi there. So yeah, we're kind of covering three different hats that you all might be wearing. And the first is as a provider or hospital. The second, as Camila just covered, is generally your employer-employee relationship. And I'm going to wrap it up by talking about kind of a third lens by which you might be looking at these abortion laws. And that's the extent to which your health plan that you provide to your employees might provide coverage for abortion. So in this universe of health plans, they're generally divided into two camps. They're either insured or self-funded. Employees generally don't know the difference. They will often just use the phrase they have insurance through their employer, because they just view it as they're able to obtain health coverage and have it reimbursed or paid for. But to the employer, it makes a big difference. An insured plan, you obtain insurance coverage from a licensed state insurer to provide those benefits, but self-funded, the employer is paying them out of its own pocket. The distinction is significant in a lot of areas because an insured employer health plan is going to be subject to state regulation, and the employer general has very little flexibility in benefit plan design. I'm going to be talking not so much about insured employer health plans in the minutes we have left. My best piece of advice here is if you have an insured product that you offer to your employees, know what it says. Know where your plan document is, know where your summary plan description is, know what your claims administrator is going to say if one of your employee participants picks up the phone and calls to see what their abortion coverage might be. So, you're probably not going to have a lot of discretion in what your insurance plan will cover, but you very well you need to know what's in it, because you can be held responsible to a certain degree. But what we're really going to be talking about is the self-funded health plan. And here's where we get this concept of ERISA preemption. So ERISA is a federal law that's been around for since the 70s. And it's administered by the Federal Department of Labor. And a key piece of ERISA is that there's a provision in ERISA law that says states can't generally dictate what goes in an ERISA plan. So employers generally have a lot of flexibility in their benefit design. Again, though, your starting point is, what does your plan say right now? Your self-funded plan probably was put together as sort of a template document from a consultant or a network provider, and it's going to have some basic provisions in there. So start with nailing down what's in there, what's currently being administered. Know your starting point to start with. So ERISA preemption, I'm going to send you to law school here a little bit, giving you the exact language of ERISA section 514. And the language just says that if you have an ERISA plan, ERISA is going to supersede any and all state laws that relate to the employee benefit plan. So that exception that I included in the quote there is what says if you have an insured plan, the savings clause says that states can dictate insured clauses. And so that's why the insured programs don't have the protection of ERISA preemption. So when we talk about a self-funded plan and ERISA preemption, you think, well, we're preempted. The states can't tell us what can or can't go in our benefit plan, so we should be safe, right? Well, most folks think that the answer should be no, but this is also going to be one of these situations where we know it's going to be litigated. And the thing that's scary and getting a lot of discussion is those criminal laws that Christy went into and detailed. Preemption is even less clear when we talk about state criminal laws. So preemption is a pretty good shield, and folks in the benefits community think that preemption should go a long ways toward preemption, but it is going to be litigated and argued over for sure. So, I mean, the basic tax principle is that if you reimburse medical expenses under your plan, that reimbursement is not going to be taxable to a participant. So there's an Internal Revenue Code section there. I gave you the citation that says reimbursements for medical care aren't taxable. The interesting thing about this tax code provision is it specifically excludes from its definition amounts expended for illegal operations or treatments. So one of the things we might see some litigation or discussion on, but for now it seems pretty clear based on current IRS guidance that the IRS is going to look at where the locality where the service was obtained to determine whether it was legal. So, if you have a participant that travels out of state to obtain an abortion and in a place where it was legal, the plan can probably feel pretty safe in reimbursing that expense because it was legal where it was obtained. And there's a couple different rulings right on point. I mean, they're back from 1973, but for now, this is the law that we know that specifically says abortions in particular, if obtained in a state where they're legal, are medical care for purposes of this this tax reimbursement. Another touch point to understand as we look at how the abortion restrictions are going to impact plans is the Affordable Care Act. There's no requirement under the Affordable Care Act for a medical plan to cover abortions. But as Christy touched on earlier, there is a requirement under the Affordable Care Act that health plans have to cover birth control. And there's also the specific listing of what birth control includes on the government agency website is that birth control does include emergency contraception, IUDs, and other methods of birth control that could fall under state restrictions. So the question mark isn't on this slide isn't whether those contraceptive methods are covered as birth control. The question is, do they fall under the state restrictions? And you know, they may here. And so what you're going to have, and this is a good introduction to sort of a standard principle here, is you may be in a position where your plan document says you have to cover it, but the state restriction will say that your participants, employees can't obtain it. So you'll have the plan sitting there saying, if you're able to obtain it legally, we can cover it, but they may not be able to obtain it legally. Of course, the Affordable Care Act has exemptions for grandfathered health plans. So again, this is something that if you haven't looked at it in a while, you need to know whether your self-funded health plan is grandfathered. And also, of course, there's a religious exemption, which depending on whether you're a religious employer, you may be taking advantage of that religious exemption to provide birth control coverage. Another touch point that is going to impact and be considered in determining the extent to which health plans cover abortions is the Pregnancy Discrimination Act. And here we have clear language in the statute and the regulation that says abortion coverage is not required, except, therefore this exception says that if you have a health plan, it's required to cover abortion where the life of the mother would be endangered if the fetus were carried to term, or where medical complications have risen from an abortion. So again, that's a Pregnancy Discrimination Act that would say that that provision should be in your medical plan. But again, if your participants don't have access to that procedure, they may not necessarily be able to submit to obtain the services. So given that background, most self-funded employer plans are feeling reasonably safe if they if they cover, a lot of them use the phrase that they exclude elective abortions, but they will provide coverage using the Pregnancy Discrimination Act standard. So if sort of the middle position, safest position is probably to just say that the plan covers abortion where the life of the mother is endangered, or where medical complications have arisen from an abortion. So what happens if you stray beyond that phrase, beyond that standard? Well, there are some employers that are choosing to amend their self-funded plans or operate their self-funded plans to exclude all abortions. Elective, non-elective, no exception for rape or incest, just take it entirely off the table and say we're not going to pay for it. That risks violation of the Pregnancy Discrimination Act and potentially the Affordable Care Act too. There haven't been any cases testing that, but again, this is an area where we're gonna have a grid of the litigation, and the issues are going to be resolved, and that's one of them. There's also a lot of plans, and they may have had this provision in them for years, or they may consider adding them to say, well, we're going to cover the Pregnancy Discrimination Act, PDA is Pregnancy Discrimination Act there. We're going to cover the PDA example for where the life of the mother is endangered. And then we're also going to cover abortion costs for rape or incest. Again, a lot of states are going to allow that exception, but a lot of them aren't. And so again, you should know the terms of your plan. And are you going to allow coverage of abortion for those, extra circumstances? If you do, that may or may not increase the risk that you'll become the target of one of the restrictive state law enforcement mechanisms. Maybe. It's hard to know there. And if you do that, also be thinking about, Christy went into the state statute definitions and talked about how some of the states use they'll use the phrase rape, some will use the phrase sexual assault, some require that notice be filed with that a police report be filed or something like that. Regardless of what the state law might say about the definition of rape or incest, as the administrator of your self-funded health plan, you're going to have fiduciary discretion in how you implement those terms. So, be aware of and be prepared and talk to your claims administrator to say, hey, we've got this incest exception in our plan. What are we going to require in order to document that that a participant, if a participant says, I'm choosing to have an abortion because I was sexually assaulted or because of incest, what are you going to require from a plan perspective to document that claim? I don't think there's a right or wrong answer here, but I think you better be prepared that those types of discussions are going to be happening on your claims administration line. And then another action that a lot of employers are taking, and this is covered at length in the news, is there's a lot of employers that are taking a stand pro-abortion and are saying, hey, for our employees that live in states where abortion is illegal or they can't obtain it, we're going to cover travel expenses for them to travel out of state and obtain abortion services. This isn't a new principle of tax law. Most plans have provisions where they'll cover travel expenses for things like transplant surgeries or centers of excellence kind of travel. So if you want to add this benefit to your plan, there's a well-worn path to do that. Again, it potentially could increase your risk of violation of a state law. And particularly, the headline, Texas is making headlines for saying they're going to go after some of the larger employers in Texas that have announced that they're going to add this, the travel benefit. There's all kinds of boring tax rules that go along with the extent to which travel expenses can be reimbursed pre-tax. Travel is limited to the hotel expenses, the overnight expenses are limited to $50 a night. If it's for a minor, you could cover also expenses of a parent to travel with them. So, if you're going to offer the travel expenses, like I say, there's kind of a slew of boring tax issues that you may already be considering because it comes up in if you offer travel benefits for other services. One thing to think about is if you're going to have a travel expense reimbursement provision in your plan, it's because these tax limits are pretty low. It's very likely that you're going to go over the non-taxable amount. So you're going to be reimbursing a portion of this of the travel expenses through your payroll as taxable wages. So be prepared with your payroll department to be handling the sensitive data of reimbursing travel expenses. I think we are just about out of time, so I'm just going to say with HIPAA. Yep.
Oh, sorry. When you're done, I just wanted to answer the questions, but finish out and then I'll answer the questions.
Yep, super quick. Just my last slide here is just tagging on to what you said earlier, Christy. Health plan or health providers obviously are covered entities under HIPAA. Don't forget that your health plan itself is also a covered entity. And so you can't use or disclose PHI unless you're permitted. And as Christy documented, there's it might not be that protective because those records could be obtained by subpoena or otherwise. So just from the employer plan side, you know, the standard provision under HIPAA is no more than necessary. So most employers are starting, you know, you always should have been thinking about HIPAA PHI here, but think about what your plan is collecting and whether it's really necessary. And so just keep the data that your plan collects to the minimum necessary because of the risk that you may have to disclose it. So Christy, go ahead. I haven't seen questions come in, but you go.
Yeah, no problem. I just want to mention, so in the Q&A, people had asked for the links that I was referring to in the PowerPoint. I cut and pasted those into the Q&A in case that's helpful. But our this presentation has been recorded and you can access it later, but also the slide deck will be available on the Holland & Hart Health Law blog. So just be aware that you can go to our site and absolutely find this entire set, this PowerPoint set there, and you can listen to the recording after the fact. I also wanted to mention, one of the questions was about, again, whether some of these federal laws, right, like, you know, the ADA, FMLA, are these federal laws going to preempt state law? The feds, the federal agencies very much assert, right, that their federal laws preempt and supersede a state law that would otherwise violate that federal law. However, again, what's happening, just like happened in Texas, Texas is suing Health and Human Services saying, oh no, you know, you don't get to do that. You know, they're claiming the opposite. So I think most of us feel like the federal law will, you know, preempt, but this is truly the wild, wild west in terms of the law. There's a lot of the stuff that there's just not going to be precedents, right? Because this is brand new. And so there's just going to be a lot of litigation before it is figured out. Someone else asked the question about under Idaho, they hadn't heard that the 20 weeks was currently in effect in this interim time. I did link to Ken Stanger's client alert that went out just a few days ago. I hope that that will help, but his interpretation is that that 20-week sprang into effect once Roe v. Wade was overturned, and it's currently in effect. And I know that he's had discussions with the AG's office, and they are in agreement that that is the case. So if you have further questions about that, please reach out to Kim Stanger.
Thanks, Christy. And this last slide, I'm not sure if you all can see, there's some additional resources like Christy mentioned. We have a link to the healthcare blog, some employment law updates, and Holland & Hart resources. And then in addition, these abortion law trackers, because things are changing. If there were any other specific questions in the chat, we'll do our best to reach out to you all directly. But I think that's it. And I hope my audio is working now, that it's over.
Thanks everybody for joining. We appreciate you.
Thank you all.
Take care. Bye-bye.